All right, we've talked about the estates in land. Those were the first 3 topics in level 1. The 4th topic in level 1 is adverse possession. That's a doctrine in the law that stems from the fact that we don't want land to lay fallow, to just not be used. So we have this doctrine of adverse possession. How do you know when you have an adverse possession issue in a fact pattern? Well, one clear way to tell is that somewhere in the fact pattern they'll tell you that there's a statute in the jurisdiction that reads, the statute of limitations for recovery of land in this jurisdiction is, and then it will give you some number of years. That kind of a statute is the statute that sets up the statute of limitations for making a claim of adverse possession. Under adverse possession, someone who has moved onto the land without a legal right to own it can, after a certain number of years, lay claim to that land and get clear title to it. So what do you need to adversely possess land and be able to quiet title? That's the name of the action that an adverse possessor takes in order to gain legal title to the property. Now, you may have in law school learned that there were 7 elements for adverse possession. You may have learned that there were 6. You may have learned 5. Various law professors and various jurisdictions, various courts, use various numbers of elements for adverse possession. The most parsimonious way to write about it is to use 4 elements. But in order to do this, you need to define the elements very carefully, because these 4 elements comprise everything that's in the 6 or 7 that some jurisdictions or law professors prefer. So let's talk about 4 elements that will cover everything that's needed for adverse possession. And those 4 elements are that the possession be open, hostile, actual, and continuous. So what's open? That means that your use is visible. It puts the owner on notice, or it should put the owner on notice if the owner were being diligent. What facts do you get that go to that? The facts may tell you that Charlie moved onto the land and openly farmed it, or hunted on it during the summer, or camped on it. Anything that would be open and visible and put a true owner on notice. The second element is that the use, the possession, must be hostile. The adverse possessor must intend to claim the land as his or her own, exclusive of the true owner. This is wrongfully claiming right, exclusively. Consent to be on the property negates this element. So if Charlie were originally invited onto the land to use it for hunting during the summer by the true owner, and he goes ahead and uses the land and hunts on it during the summer for 20 years, and now wants to raise a claim of adverse possession, he's going to have trouble with that because he had permission to be there, so his use was not hostile. It wasn't wrongfully claiming right to it exclusively. Now, where else will that come up? We already talked about joint tenants. We talked about rights among co-tenants. We talked about the fact that co-tenants can oust each other. What if a co-tenant lives on the land for 20 years and the other 2 co-tenants never approach the property, and then 20 years later when the co-tenants try to enter the property, the one living there says, nope, it's not yours anymore. I've lived here for 20 years. I'm claiming it by adverse possession. What's the co-tenant's problem with that? He has permission to be on the property. So in order for a co-tenant to adversely possess and gain exclusive title away from the other co-tenants, there must be actual ouster. That's what would be needed to meet this element for adverse possession.
So you have a rule. No adverse possession among co-tenants unless there is an ouster.
Exactly, and that one you need to remember. Bar exam writers, law school exam writers know that it's easy to forget that one. Okay, the third element in our 4 for adverse possession is actual use, and that means use consistent with the character of the land. So if your fact pattern tells you that this land was used for a summer vacation retreat, then the adverse possessor can use it as a summer vacation retreat, and that's actual use. That's consistent with the character of the land. If it was a farm, the adverse possessor needs to farm it, and so on. And the final element in our scheme of 4 is continuous use. And that means continuous for the statutory period, whether that's 10 years, 15, 20, or 30, whatever you're given for the statutory period in the jurisdiction. Now, the issue under continuous use is always going to be in your fact pattern that it wasn't one person who used the land for whatever the statutory period is. It will have been sold or passed down in a will. So you're going to need the issue of tacking. When may the adverse possessor tack his or her time on the land onto the time of people before him? So the issue will be tacking. Tacking for adverse possession requires privity, some relationship between the successive people. In other words, it can't be just one homeless person after another with no relationship between them. There needs to be a conveyance there, or a will, or some other relationship among the people. There can't be any gaps in time. So if one person leaves the property for a month, the next person comes on, that's a gap in time, and that ruins tacking. And another issue in tacking is, can you tack disabilities? So, what's a disability for adverse possession purposes? It's that the owner must be under a disability at the time the adverse possession began.
Okay, so
that's
an important point, because at the time it began. So in other words, let's say the adverse possessor enters when the owner is totally sane, and the next day the true owner becomes incurably insane.
Too bad for him. The adverse possession started when he was sane. That's it. The time starts running.
Okay.
What is a disability? Insanity. Infancy, being under 18 years of age, or whatever the definition of infancy is in that jurisdiction. Incarceration, someone's imprisoned. Now, can we tack together insanity and incarceration? No. No tacking of different disabilities.
Mm-hmm. So if you're insane at the time that the adverse possessor enters, and then you become cured, if that's possible, but the second you become cured, you're incarcerated.
Or even before you become cured, you're incarcerated.
Yeah, and then you're basically cured in jail. Mm-hmm. You can't tack those. You can't add one disability to another.
So the disability that existed when the adverse possessor entered the property is the one that's going to count. And when that disability is over, adverse possession begins. So now what if the person had two disabilities, which is common? Our prisons are full of the mentally ill. Mm-hmm. So let's say someone is mentally ill, insane, and incarcerated, and an adverse possessor enters the property while this mentally ill person is incarcerated. Which one are we going to count as the disability?
Whichever one lasts the longest.
Exactly. Now the adverse possessor is going to want to argue that it's the shorter one. The person with the disability is going to argue, or their guardian is going to argue that it's the longer one.
And they will prevail.
And they will prevail, yeah. Now, another issue in adverse possession is, to what extent do you adversely possess the land? To what extent do you gain title? And that is a color of title issue. So if the adverse possessor, for instance, buys the property, if the property is conveyed to him or her under some purported deed. So let's go back to our joint tenancy example. We have a joint tenancy, and one of the joint tenants sells the land to a buyer with a quitclaim deed. And this joint tenant, who actually owns only a 1/3 ownership, sells the deed, a quitclaim deed, to all of Blackacre. Really only owned 1/3, but the buyer believes that he bought all of Blackacre and has a purported deed that says all of Blackacre.
Okay, now let me just back up. Quit claim deed means that you sell only what you have without any promises or warranties. So what did the seller actually have?
1/3 ownership.
Then that's all the buyer gets. Now there are a couple of exceptions on that. One is it has to be proportional. In other words, you can't adversely possess 1 out of 100 acres and expect to take under color of title the whole thing. So it has to be proportional. The second exception is if you have a barrier, either artificial or natural. So let's say we have 100 acres and the adverse possessor takes under color of title, meaning that the adverse possessor is given a deed of some sort, and there's a river that runs right through the property, cutting it right in half.
Or a highway.
Or a highway, and the adverse possessor just stays on one side of the highway. Even though the adverse possessor has color of title, the adverse possessor is only going to get that half on which the adverse possessor lived and resided and developed. So the barrier can be artificial or natural, doesn't matter.
And there are a few other points about adverse possession, just quickly, that come up relatively often. Adverse possession only works against the estate as it existed at the time. So if the adverse possessor goes onto land that was a life estate, adverse possessor can gain only what the life estate owner had. So might adversely possess and quiet title and get ownership to the land and have the person with a life estate die the next week, the adverse possessor is out of luck. His ownership ended because the life estate ended. Now, there can be no adverse possession of a future interest that has not yet been created. That won't work at all.
So in other words, where it hasn't become possessory.
Exactly. And finally, and probably most important of these extra points about adverse possession is that title acquired by adverse possession is not marketable title. It's not marketable title. In order for an adverse possessor to acquire marketable title, the adverse possessor has to go into court and ask for a quiet title action in order to gain marketable title to the property. So if a buyer is trying to buy property from an adverse possessor, we will come to this later, one of the implied warranties under the land sales contract is that the seller will, at time of closing, deliver marketable title. And an adverse possessor cannot do that without doing a quiet title action.